All right, so good morning, everybody. I just wanted to welcome everybody, and it's nice to see some faces on here this morning. I think we have the Maritimes represented pretty well. We have Ian Picard from Halifax, and we have Andrea Williams from Newfoundland. And we're from New Brunswick, so pretty well covered this morning. Before we get started with the webinar, I just wanted to remind everybody that it will be recorded, so you can watch it later if you've missed something, or if you want to share it with your coworkers, your friends, whatever, you can do that as well. It'll be on the Chamber's YouTube channel. At this time, if everybody wants to mute their microphones, that would be great. And if you have any questions, we'll ask you to put them in the chat, and they'll be addressed later on in the presentation. So today we have with us, as I mentioned, Ian Pickard, from Ian Pickard is a seasoned labor employment partner based in McGuinness Cooper, Halifax, Nova Scotia's office. Andrea Williams is a labor and employment lawyer based in McGuinness Cooper, St. John's, Newfoundland and Labrador office. Ian and Andrea advise and represent both unionized and non-unionized employers in all workplace issues, including hiring, discipline, workplace development, implementation, enforcement, collective bargaining, occupational health, safety, and termination. Great to have you guys here this morning with us, and take it away.
Hi, everyone. So I'm going to share my screen here now. So let me know if you have trouble seeing it. Is it, are we up and running?
Yes, looks great.
Perfect. Yeah. Hi, everyone. So as mentioned, my name is Andrea, and I'm an associate here practicing labor and employment in McGuinness Cooper's St. John's office. I can assure you that the weather behind me looks much brighter out than it is today. I think we're in our fourth consecutive day of just thick fog. So I know you've got a gray day there in Fredericton, but I can assure you that we're also very much looking forward to seeing the sun sometime soon. So Ian and I are here to speak with you today about COVID-19 in the workplace, specifically with respect to the COVID-19 vaccination and COVID-19 testing. So I believe I speak for everyone when I say that the COVID-19 fatigue is certainly starting to kick in. Right now, Canada is heading into its third wave right now, and we see many other provinces starting to lock down again. I, for one, can't wait to be able to do these presentations in person and not have to look at a laptop screen instead of seeing faces out there. So that's certainly something that we're looking forward to. Hope is on the horizon, though. Vaccines are starting to get rolled out and are starting to become more readily available. So with that in mind, what we hope to do today is provide you with some guidance on COVID-19 vaccination policies and testing policies in the workforce. So as employees start to return to the workplace, what measures can be taken to ensure that it is safe to do so. So we'll start with a quick poll just to get an idea of who we're speaking with. So what sector does your business operate in? So there's 5 options there. So if you could click what best represents you and your organization. Give it a couple more seconds. Right now we have the vague other, so it's safe to assume from that we don't have many here from the health sector, energy, technology, or manufacturing or processing. So I'd be interested to hear what industries you represent, but we'll move on for now. And the advice we gave is going to be pretty applicable no matter what sector you're in. So I'll stop that. So the main question that I'm sure many of you are wondering is, can I implement a COVID-19 vaccination and/or testing policy in the workplace? And as lawyers, we'll give you the typical answer of, it depends. And what we mean by that is that one size does not fit all. So it really depends on the nature of your workplace, the industry you operate in, what it is that you do, the size of your office, the amount they interact with each other, etc. So it is really a case-by-case assessment. But what we'll do today is provide you with some guidance to help you make that determination. So COVID-19 is unique. So with that, there is special considerations. The first thing we advise you do is look internal to your organization. And what that means is look at the nature of your business. What is it that you do? Is it possible to have employees working at home? Are your employees in the workplace working in close proximity with one another? Is your work environment unionized? So are you subject to a collective agreement? And if so, what does that collective agreement say? Does it in fact address vaccinations in the workplace, or does it provide you with some other guidance as to what is reasonable as an employer policy in the workplace? Also, we recommend looking at other factors that may be unique to COVID-19. So for example, do you employ predominantly Indigenous persons, or is your workplace located in close proximity to an Indigenous community? We see that this population is especially vulnerable to COVID-19, so that is certainly something to consider as well when determining whether a vaccine or testing policy is reasonable in your work environment. That said, there are also external factors that you must consider as well. So privacy law. An employee has a right to privacy, specifically with respect to medical documentation. So there are certain considerations surrounding what you can or cannot request as an employer. Also, general legal principles and legislation. So considering occupational health and safety legislation, human rights legislation, as well as public health legislation. And of course, we can take some guidance from analogous case law. So we've seen some cases whereby employers have implemented flu vaccine policies. So we can take some guidance for that in determining what the legal landscape will be with respect to COVID-19 vaccines. So looking at public health legislation, generally speaking, across Canada, public health legislation treats immunization as a pretty invasive procedure. So right now, immunization programs are voluntary. It's certainly subject to some debate whether people feel comfortable getting the vaccine or whether there's widespread acceptance of what vaccines. But so generally speaking, the government's approach to that is to make vaccinations voluntary in nature, and the person's consent is required before they get a vaccine. That said, I note in New Brunswick, the Public Health Act actually provides the Lieutenant Governor and Council the authority to make regulations regarding the vaccination of residents. So right now in New Brunswick, vaccines are voluntary, but the government does have the power to make them mandatory. So that's something to certainly keep an eye on as we move forward. As if vaccines do become mandatory, well, that will certainly speak to the reasonableness of a vaccine policy in the workplace. We also look at occupational health and safety legislation. This legislation confers a legal duty on employers to take measures that are reasonably practical to ensure a safe and healthy work environment for its employees. So whether or not COVID-19 vaccinations and testing falls into an employer's legal duty under occupational health and safety certainly depends on the nature of the workplace and the risk that COVID-19 poses, but the employer's legal duty to provide a safe work environment certainly underlies some employer motivation for implementing such policies. So looking at some of the legal case law, I'm sure many of you have heard the phrase that we are living in unprecedented times many times before, and that certainly applies with the case law. So unfortunately, there's not a lot of legal precedent with respect to COVID-19 testing and vaccination, but there is certainly analogous case law that we can use to inform our analysis. So we'll provide you with a brief overview of the legal landscape and how COVID-19 vaccination and testing falls into that legal landscape. So one of the leading cases on the reasonableness of COVID-19 precautions actually comes out of Newfoundland, and that's the Taylor versus Newfoundland and Labrador decision. So this decision was a challenge to the Newfoundland and Labrador travel ban. And for those of you who are not aware of this travel ban, at the outset of the COVID-19 pandemic, the Newfoundland and Labrador government implemented a travel ban on those entering the province. So those wishing to enter the province who are not residents of the island or Labrador had to apply to essentially get permission to come here and then undergo the 14-day isolation. So Ms. Taylor was hoping to return to the province. She had some family here and was unfortunately denied entry, and she challenged this decision on the basis of mobility rights under the Charter. So this went to the Supreme Court of Newfoundland, and Justice Burrage upheld the travel ban. And in his decision, he looked at the fact that while Taylor's mobility rights were infringed and she was unable to travel here, and this certainly caused her mental anguish, the applicant's right to mobility must give way to the common good. So we see here with COVID-19 really that emphasis on collective safety. We next look at the KVP decision. This is a 1965 decision, so it's well established, and certainly for unionized environments. It looks at the reasonableness of employer policies when they're unilaterally implemented. So in order for a policy to be reasonable and to be effective, it should be consistent with the collective agreement, reasonable, clear and unequivocal. It must be communicated to employees in advance. Employees must be given notice for what happens or the consequences for a breach of the policy, and it must be consistently enforced. So perhaps the most helpful case law in this circumstance comes from the line of cases with respect to the flu shot. So in these cases, employers implemented policies with respect to the influenza vaccine. So for example, in the Trillium Ridge case, the employer was a retirement home and implemented a policy whereby staff could demonstrate that they had proof of the influenza vaccine or take antiviral medication, or they could stay off work on unpaid leave until the influenza outbreak was over in the retirement home. So the arbitrator in this case upheld the decision and stated that there was ample evidence to show that the vaccines were effective both in reducing the spread and the severity of symptoms. So in this case, given the vulnerability of the population or the residents of the retirement home, it was reasonable in these circumstances. Looking at the Chinook Health decision, similarly in this case, the employer implemented a policy that provided that unimmunized staff and those in the first days of antiviral therapy could take unpaid leave or otherwise take bank days or vacation days, but they were not to enter the workplace during this time. Again, the arbitrator balanced the privacy interests of the employees against the interests of protecting the residents and the patients of the employer, and stated that this policy was reasonable. We also saw this in the Health Employers Association of BC. This case was in 2013, and in this decision, the employer implemented a vaccinate or mask policy. So employees had the option of either demonstrating proof of vaccination or wearing a mask in the workplace. And in this decision, the arbitrator applied the well-known Irving Pulp and Paper alcohol and drug testing decision, and in balancing these interests, looked at patient safety and held that outweighed employee privacy in this circumstance. Finally, the Alberta Health Services decision. This is a 2020 decision, but I do note that it's one of the few 2020 decisions that were made outside the realm of COVID, so before February or March of last year. And in this decision, the griever was a nurse who had been exposed to measles at work. And as a result of this exposure, the employer gave her the option of quarantining for 17 days or providing proof of vaccination. In this case, the arbitrator applied the Trillium Ridge case, so the retirement home decision that we discussed first, and held that management is within its rights to restrict an employee from coming to work in this instance. However, in this case, management the employer did amend its policy with respect to the amount of vaccines that were required. So the second booster shot for the measles, but did not clearly communicate this to the workforce. So the employer was not able to rely on these amendments. So in this case, we see the balancing of interest approach, but we also see the importance of those KVP principles mentioned on the last slide, and that in implementing a policy or making changes, it should be clearly communicated to the employees. So I know that's a lot of information and a lot of cases thrown at you, but if we were to take any takeaways from these cases, the first thing is that all these cases discussed, and most cases with influenza vaccine policies, have to do with the healthcare sector. And as we saw in our initial poll here today, I don't believe anyone here represents the healthcare industry. So in looking at whether it's reasonable for your work environment, certainly these are things to consider as the healthcare industry deals with vulnerable and sick members of the population, or retirement homes dealing with elderly persons who are especially vulnerable to diseases such as COVID-19. In all these cases, the arbitrator employed a balancing of interests approach. So weighing the risks of influenza and the potential harm that it could have on the work environment, both to employees and patients, against employee privacy. And in these cases, the potential harm outweighed employee privacy, but again, that's a case-by-case assessment. Finally, or thirdly, sorry, in all these cases, the options provided were not mandatory. So employees were not mandated to get a vaccine in the sense that they had to get a vaccine or be subject to discipline and or be terminated. Employees provided options, being unpaid leave, vacation, wearing a mask, etc. So the more options that are available to employees may speak to the reasonableness of the policy. Finally, in most of these decisions, arbitrators do place significant weight on the medical evidence. I would say we are fortunate in the sense that COVID-19 is a global pandemic, so we have scientists from around the world working on this as we speak. So while this presentation in April 2021, there's a fair amount of evidence on the effectiveness of vaccines, we hope to see more in the coming weeks, years, and months ahead of us on the effectiveness of vaccines in terms of the severity of symptoms, immunity, as well as their effectiveness in preventing the transmission of diseases. So certainly keep an eye on the medical evidence, as that can help to inform the reasonableness of a testing or vaccination policy as well. So that's a brief overview of the legal landscape surrounding vaccination policies. I'll turn it over to Ian now, who will provide you some practical advice on vaccine and testing policies in the workplace.
Thanks, Andrea. Before we move on to the next slide, I just sort of want to give an overview of where we are, just a recap of some of the parts that Andrea talked about. It's interesting from a legal perspective that even though in all of our lifetimes, COVID is a brand new legal issue, lawyers are pretty comfortable. Certainly, Andrea and I are pretty comfortable with how we feel a court would deal with these with the issues of mandatory testing and dealing with testing and vaccinations as it relates to the workplace. By looking at what courts have done in the past, it's very interesting that when you look at the Taylor decision that Andrea mentioned from Newfoundland, we're really aware of 3 decisions, all of it rendered with respect to COVID. One of them was a travel ban. The other 2 are unionized workplace decisions. But the decision, the Newfoundland decision, is interesting in that the judge in that case, in Taylor, went back and relied primarily on a decision from the U.S. Supreme Court that was decided in 1905 during a smallpox issue and dealing with compulsory vaccination. So that's 1905 case law, in which the U.S. Supreme Court found that the common good is more important than independent rights. And so when you follow that through and look at the flu vaccination cases, there's really 3, in my opinion, there's three key takeaways that we can apply equally to vaccinations with respect to COVID. The first one is that when they were first faced with this issue, that the courts and arbitrators were saying, well, as long as the employee is not being disciplined or punished, and they're simply losing wages or vacation days or till days or what have you, as long as they're not being terminated, then the employer is reasonable in saying, well, you have to get the flu vaccination if you want to work in a healthcare setting. So that's number one, is that it and we'll come back to this, but it cannot be punitive, but it certainly can have some impact on the employee from a wage standpoint. And then we move forward with the competing case law with respect to mask or vax, and again, the second principle is that the one of the lines of cases is that the employer's policy is reasonable as long as the employee has an option with respect to wearing the mask if they're refusing to get the vaccination done. And then in the Ontario cases, which go the other way, the good news about those cases as we apply it to today's world is that those cases are disputing the medical science that wearing a mask or getting vaccinated is somehow going to impact on the spread of influenza. When it comes to COVID, I think the medical science is pretty comfortable to say that the vaccine is going to very much help stop the spread of the illness. So there's a lot of really good takeaways from the old case law that help us answer these questions. And there are two decisions that deal directly with COVID in the workplace. One of them mentioned in the slideshow. The other one's not, which we'll talk about. But they do support the fact that it's very much reasonable for an employer to have a policy with respect to dealing with the impacts of COVID on that employer's workplace. Those are unionized settings. I had a quick look at people answering questions about the type of workplace that you all work in. I would expect that 2 or 3 of you are unionized. Certainly the person who said municipal government, I expect that some of you are unionized. But what we're going to talk about for the rest of this presentation applies equally to whether you're unionized or not, though if you are unionized, the case law is perhaps more in your favor based on the KVP test that Andrew talked about. So we'll move forward now with the slides with that overview. So the first question I'm going to ask is whether you think you can require your employees to have a COVID-19 test before attending work. So let's answer that question and see what people think.
Sorry, I'm just having a moment here with my polls. Let me try something else here. Oh, here we go.
Okay. Yes, interesting results, and thank you, Cynthia. I assume that all municipalities are unionized, so I'll show my true colors by saying that I'm happy to hear that yours is not unionized. So the answer is interesting with respect to, and we'll come back to that. So 60% of those don't believe that you can require your employee to have a COVID-19 test before attending work. That's great. Let's go to the next slide, Andrea, before we talk about the answer. Yeah. So the Fluorescence Care nursing home case is a unionized case, and in that case, which is obviously an extremely recent case, the employer was indicating that it was mandatory that everybody be tested every 2 weeks, and certainly if you refuse the test or refuse to participate in the test, then you would not be entitled to attend work. And in that case, the employer balanced the interests of privacy versus the arbitrator balanced the interests of privacy versus infection. And obviously, at that time, when this case was decided last spring, a lot of the union was arguing a lot of uncertainty surrounding COVID. But the policy was upheld as being reasonable. And as Andrea mentioned, the union was making arguments about the random drug and alcohol testing. And as many of you may know, you're not entitled to test your employees for randomly for drug and alcohol testing, no matter what type of workplace you have. And the Supreme Court of Canada has weighed in on that. So the union is saying if you can't just pick people at random and make them and test them for drug and alcohol, you shouldn't be able to pick people at random and test them for COVID. The arbitrator said, no, it's not the same at all. You can't make that analogy because certainly in the healthcare setting, we need to know whether people have COVID and whether they're safe to come to work or not. So that case certainly stands for the proposition that in a unionized environment, which is the only case that's been tested, it is reasonable to have a policy that requires your employees to be tested. So let's have a look at the next slide, and then we'll come back to. Okay, so when it comes to testing, I would say based on the vaccine cases and such that again it depends to a certain extent on your workplace. But number one, if it's difficult for your employees to work from home, and number two, there is a certain element of a requirement for your employees to either interact with each other or interact with the public in a public sector situation where you're a service industry, then it is reasonable, in our opinion, for you to have a policy that requires your employees to be tested. They obviously have to know in advance of the policy and that they can test negative for COVID prior to coming to work. So that would apply in manufacturing industries where a lot of people are working together. It certainly would apply in healthcare industries, and it certainly would apply in service industries. That you could have a policy that requires that your employees be tested. Remembering that if the employee refuses to be tested, then the outcome of that is not that they're terminated or they lose their job. It's that they simply are placed on some type of leave of absence without pay based on their decision to not be tested. And so that's sort of been our advice throughout. It obviously is a policy that you would need to develop and announce to your employees in advance. But it's interesting because employers have been very reticent in coming up with a policy that requires employees to be tested prior to coming to work. Last March and April, it was difficult for people to get tested. A year ago, even in the fall. Now, certainly in Nova Scotia, and I expect it's similar in New Brunswick, it's fairly easy to get it to get a test. So we'll move on to vaccinations now. But certainly with testing, you certainly can require your employees, depending on all those factors I talked about, if they need to be in the workplace, they need to work with others, or need to work with the public, that you could require that they be tested. So next slide. So can you require your employees to have a COVID-19 vaccine before attending work? Let's go with that one. Let's see if what I said has changed people's answers. Okay, so 70% have said no to whether we can require employees to have a COVID-19 vaccine before attending work. So let's go to the next slide, and the next one. Okay, and I should have mentioned earlier, as Wendy said off the top. Feel free to ask any questions in the chat function anytime that you want, and we'll deal with those. The first and most important point is that we certainly cannot have mandatory vaccinations as a general rule for our employees today, certainly in Canada. The main reason for that, as Andrea talked about, is that the New Brunswick government has the ability under the Public Health Act to mandate vaccinations, and it's chosen not to. And my opinion is that no government in Canada or the federal government is going to mandate vaccinations at any time. So without the government mandating vaccinations as a legislative requirement, then we're not going to be able to mandate as employers that our employees be vaccinated or else. There may be exceptions for unique and highly vulnerable workplaces. And the big question when it comes to mandatory vaccinations is that until such time as any, and this will color a lot of what I'm going to say in a second as as an exception to my statement here about mandatory vaccinations, but until such time as any one of your employees, no matter what their age is, can basically walk down the street and get a vaccination. Until we're in that world, which we're not in yet, certainly in Nova Scotia or New Brunswick or Newfoundland, until we're in that world, we can't even really have a conversation about mandating vaccinations, because until the employee is able to go get one, if you mandate it easily, then we're hard pressed to make any type of policy as an employer. Certainly in Nova Scotia, we're still dealing with the over 55 population group, and I expect it's somewhat similar in New Brunswick when it comes to who can generally get a vaccination. So there's a large segment of your employee group that isn't even eligible to get one, which really impacts on this conversation. But all that aside, I guess the purpose of this webinar is so that you are aware that in the months to come, once vaccines are more generally available, then you are able to create a vaccine policy in your workplace in which you are saying to your employees that we want you to get vaccinated. And that we're saying that if you want to come to work, you're going to need to be vaccinated. So I would expect by June in Atlantic Canada, you will be able to create a policy. The key aspects of that policy, once we get there, will be no discipline for refusal. So that means that the employee cannot be terminated. It's not vaccinate or else. It cannot be that, or else lose your job. And you have to create a policy that is specific to the vaccination issue. So if we have a look at the next slide. So first of all, and the expression that I use all the time in giving this presentation is that your mindset going forward, once we're in that space where vaccinations are generally available, is that any employee who refuses to get the vaccination needs to have an off-ramp. They need to have the ability to say, well, I don't want to get vaccinated, so what's my path? and you need to be able to create a path for them. And as long as that's your mindset, then in my opinion, we're all going to be fine. And so just to jump around a bit, the mindset has to be, as I said before, is there a way that employee can work from home? Is there a way that you can mitigate the workplace risk, as the first bullet says, with respect to that employee? So you say, we want everybody to be vaccinated. The employee says, 1 employee, 2, 3, I don't want to get vaccinated. I am not getting vaccinated. Then you have to say, well, how do I mitigate the risk to the rest of the workplace? Because if everybody else is getting vaccinated, we don't want you to not be vaccinated. So can that person work from home? Can that person work in a way that minimizes the risk to the business or to the public? That's number one. Number two are there other options and alternatives available with respect to that situation? And what I mean by that is the off-ramp that I talked about. Can that person, if they can't work from home, if you cannot minimize the risk, then can they take vacation for a couple of weeks or a month till we get past this? Do they have other money available to them? Or, and this is where it gets a little bit dicey with the legal advice, but our legal advice based on prior case law is your policy can say that they would be mandated to take a leave of absence without pay if that is the last option available. And certainly that's our advice. If the one exception to all this is that, and I haven't seen any case law on this yet, but if their reason for not getting vaccinated is truly religious based, I think that's the question. If they refuse to get vaccinated, and we accommodate, I apologize. I'll come back to that question. But if they truly have a religious belief that creates the duty to that is a human rights issue, and it's not just a wish to not be vaccinated, and it's truly a religious based issue, then that complicates things from the duty to accommodate. I just want to clarify, when this slide says discipline for non-compliance, that means if they don't comply with your policy in the sense that they don't agree to work from home, or they don't agree to work in a satellite office, or they don't agree with the alternatives that you've put forward, it's not discipline for not getting vaccinated. You cannot discipline them for them refusing to vaccinate, but you can discipline them for them refusing to follow your direction as to what the off-ramp is. So I just want to be very clear about that. And the Supreme Court of Canada has spoken on that in other case law. They can be disciplined for not complying with the policy. They can't be disciplined for not getting vaccinated. I hope you understand. I hope you understand that. So if you say work from home and they say no, they can be disciplined for refusing to work from home. If you say you're on a leave of absence without pay and they say no, they can be disciplined for that. But that all has to be in your policy. If you are working in a unionized environment, then have a conversation with the union in advance. The KVP test that Andrea talked about is key if you're in a unionized environment, which means that it cannot be contrary to your collective agreement, and it has to be reasonable. But the biggest takeaway is look at your workplace, determine what an off ramp would look like for that employee who's refusing to get vaccinated. So I think the next slide is the last slide, then I'll just come back. Is there one more slide, Andrea? No. Okay, go back then. So I just want to clarify a few points. So number one is, before you create this policy, if you want to have one, we have to wait until vaccines are generally available to the entire population. So we're a little bit premature on that. I certainly have no problem with you as an employer telling your employees in an email or otherwise, if this is the direction that you want to go, that if they qualify for a vaccination, that you're expecting that they get one, because you as an employer want to move in a direction of having your employees vaccinated. Number two is, once an employee says no, then you have to individualize their situation. So not a general rule, but an individual rule. So Andrea says no, then I got to look at what I can do with Andrea. Can Andrea work from home? Can Andrea work somewhere else? Can she work in a way that's not interacting with the public? On and on and on. So that's that. We have to follow the medical evidence, but I think right now the medical evidence is pretty clear that vaccinations are the path forward, and we need to be able to manage in order to get out of this by late summer, early fall. We need the vast majority of people to be vaccinated, and so we can create this policy going forward. So just to answer the question, no. I mean, the one thing that's very clear about COVID is that an employer can never be, certainly in Atlantic Canada, New Brunswick included, an employer can never ever be responsible for a situation where an employee ends up with COVID, no matter how, why, or where. And the reason for that is the workers' compensation legislation. Every employer in Atlantic Canada is protected from any type of lawsuit or claim by an employee for a situation where the employee suffers any type of injury or illness as a result of the workplace. So your WorkSafe New Brunswick protects you completely from any situation where an employee is saying, I got COVID because of what you did or because of a situation you put me in. Their only avenue, which is not even clear that you can prove where you got COVID, but their only avenue would be to pursue that claim through WorkSafe New Brunswick. There would be no risk to you with respect to that. So the only risk in this situation when it comes to the off-ramp scenario, the only place where it gets a little, as I said earlier, dicey, is if we're telling an employee, look, we've looked at every possible avenue here, and for all these reasons, if you're refusing to be vaccinated, then you're going to have to go on a leave of absence without pay. That is the only time in all of this that that creates some risk, and we don't know what courts will say about that, whether that is a constructive dismissal or otherwise. But based on past case law, we're pretty comfortable that if we can show that was the only off-ramp available in the situation, that it was a reasonable response by the employer to say to the employee, you're going to have to take a leave of absence without pay until we reach herd immunity and the risk is gone. And then you can come back to work even though you're choosing not to be vaccinated. So that's the answer to the main question about whether we can require employees to be vaccinated. I guess the answer I would lean much more towards yes, once vaccines are generally available, as long as we create the safe off-ramp. So that's the presentation. We're certainly happy to answer any questions that folks have, either in the chat function or we're a small group. So if anybody wants to unmute themselves and ask a question, then feel free to do so. But those are that's the presentation, and we're like I said, happy to answer any questions.
I had a question about what you just said.
Okay.
About they could come back later once their herd immunity was okay. Do you have to take them back?
Yes, I mean, that's the whole, yes. So the easy answer is yes, because what we're very much advocating is a non-disciplinary response to the employee's refusal. And I would say, though, I mean, to be completely transparent, there certainly are law firms or lawyers in Atlantic Canada who are being much more aggressive than us and saying that once we get to readily available vaccinations, that and you're working in an industry where your employees are either working in close proximity or working with the public, that if an employee refuses to be vaccinated, that could be grounds for termination. I am not comfortable, McGinnis Cooper is not comfortable in giving that legal advice. We think that is too aggressive and it would not be supported by the case law. So if you, based on what our advice is, you would have to take that employee back once they've been on a leave of absence for 2 or 3 months to get to herd immunity. But you'd only take them back when it's 100% safe and that there's no impact on no risk to your other employees or to the public based on their refusal to be vaccinated. So I would delay taking them back until it's belt and suspenders safe, but you would have to take them back.
Okay, thanks.
Based on the advice that we're given, yes, which we certainly think is the prudent course of action. Any other questions?
Hi, Ian. It's Cynthia. So I have sort of to follow up to what you just said, I have public works staff that are not unionized and they're really hesitant to take the vaccine. So if they are off, if we put them on the leave of absence without pay until we decide it's 100% safe, who makes that decision that it's 100% safe for the public? Because these guys interact with the public all day long. Who makes that decision?
That would be, yeah, that's a great question, Cynthia. That would be a public health decision. That would be when the public health when the chief public health officer for the province of New Brunswick says that we've now reached herd immunity. So this whole situation, the whole pandemic is now at an end as far as New Brunswick goes. I'm not talking about you or I saying your public sector municipality, your municipality is 100% safe. I'm talking about a public health directive that, the pandemic is for all intents and purposes over. It would only be at that point when the vaccines become irrelevant that those people would be able to come back to work. And I should have clarified that. And I think, Cynthia, if any of you on the phone, but Cynthia raised it, if you're as an employer, you're inclined to go in this direction of creating a policy that you want your folks to be vaccinated for the reasons that you're saying, and it's not possible for them to work from home. We have to start talking the talk now. We have to start letting these employees know verbally and otherwise that that's the direction that we're going to be going, right? We obviously can't go there now because vaccines aren't generally available, but they need to know that over the course of the next couple of months, we fully expect that they're going to get vaccinated when they're able to get vaccinated. That because of the nature of your workplace, that's our expectation. And if they're strongly thinking otherwise for non-religious based reasons, then they need to know that there's going to be a problem in the coming months for them. It's only fair to make them aware of that, and that you're going to create an off ramp for them. But they need to understand that that's where you're headed. And this whole thing about the AstraZeneca vaccine, if that's the issue, then that's a little bit more of a complex issue. And I should have said that earlier. I mean, that's a real fly in the ointment of this whole discussion, is the AstraZeneca vaccine, because, I think it's been, I mean, I'm not a doctor by any stretch of the imagination, but I think it's been over exaggerated to a certain extent. But if an employee says, I'm not getting the AZ vaccine, I'm waiting for something else, we probably have to be a little bit more lenient in that respect, because that whole AstraZeneca thing is a bit of a fly in the ointment. I should have said that earlier.
And again, I guess that speaks to accommodation issues too. If this employee has a history of blood clots or something of that nature, then that could speak to your duty to accommodate as well.
No, that's an excellent point, Andrea. If somebody's raising the AZ issue, the blood clot issue, we have to deal with that as a completely separate issue. But over time, anybody who doesn't want the AZ vaccine is going to be able to get one of the other ones. So that's going to work itself out in the next 90 to 120 days anyway. I really think that come the summertime in New Brunswick, everybody's going to be able to get a vaccine of their choice. And that's when this issue is really going to come to a head.
Fingers crossed anyway.
Fingers crossed anyway, exactly. Any other questions? Sorry, go ahead.
I have a question if you have another minute. In regards to an employee who's already on an accommodation and will soon be receiving the vaccine, they are asking me, should they provide proof that they've had the vaccine before they can return to work? And if so, do they have to show that after the first shot or the second shot or both?
Well, yeah, I mean, that's a good question. I mean, if they're on an accommodation because they're immunocompromised and they're not coming to work, then I don't think that they could come back to work until after they've had the second shot. But that's just me. I mean, if the employee's the one, was it the employee the one that asked for the accommodation, or did you push the issue?
The employee filled out our accommodation form to work from home due to, immune compromised. So we are accommodating this person. They are working from home full time.
And now they're saying they want to come back because they've been vaccinated.
Correct. Yeah, they have a date for the first shot, but they believe there'll be a second shot. So they're eager to get back to work, but they've proposed the question to me is, do they have to show proof that they have been vaccinated?
Yeah, I mean, my answer in that scenario, because this was all employee initiated, is I don't really care. I mean, whenever the employee believes that they're safe to come back, they can come back, right? Because this is an issue that was raised by the employee. So I want once the employee and the employee's doctor believe that the employee is safe to return, then the employee can return. We don't really need proof of anything in that scenario. It's like an employee saying, I can't come to work because I have this condition, and then the employee saying, I'm better now, I'm coming back. So I don't really need any proof in that scenario. Does that make sense?
Yep.
Yeah.
No, thank you.
All right, if there's no more questions, we're certainly happy to have been able to do this. And certainly on behalf of Andrew and I, thank you for your time, and hopefully we answered some of your questions about vaccinations and testing.
Yes, thank you very much. It's been a great presentation and a lot of great information for everybody. And just a reminder that it will be shared on our YouTube channel. So anybody, if you want to clarify some information that maybe you missed or something, you can go back and rewatch it or share it with your coworkers or whatever. So thank you very much and have a nice day, everybody.
Okay.
Thank you.
Thanks.
Bye-bye.
Bye-bye.
But